We have an ordinance for the city of Summit, which creates a Morris Broad Crossroads Overlay Zone District. And although that was number 6 on the agenda, I think we're going to move it up now and just give a chance to go through that. Now, tonight we'll hear from 2 professionals to lead us off on this matter. I've asked Mr. Warner to give the board a summary of the legal parameters of what a consistency review is, which is what we're being asked to do tonight, and which is guidance as to what our legal responsibilities are and what we are and are not going to consider tonight. After that, we'll hear from Mr. Burgess, who will explain exactly what the overlay does and how it impacts the master plan and how it is impacted by the master plan. So I ask Mr. Warner to start.
Certainly, Mr. Chairman, thank you. This is a Section 26A of the Municipal Land Use Law referral of the ordinance to our planning board, as we've done before. In the process, the governing body, the Common Council, introduces development regulations, DROs, and those are referred to under the MLUL, the planning board, for master plan consistency review, after which there could be a second reading by the Common Council and a public hearing at that time. So Section 26A sets forth our statutory responsibility for a referral. Prior to the adoption of a development regulation, the planning board shall make and transmit to the governing body within 35 days after referral a report including identification of any provisions in the proposed development regulations which are inconsistent with the master plan. Sometimes the question arises, is this a public hearing? The answer simply is no. It is not a public hearing. The public, and nor is the planning board considering the merits of the ordinance. Whether you're in favor or against, that has nothing to do with the planning board's narrow statutory authority on a master plan consistency review. In fact, the Cox-Koenig treatise refers to it and says clearly the statute does not require a hearing, nor does it require the matter be open to public comment, and no one is deprived of an opportunity to speak to concerns raised by the ordinance, because when the matter is returned to the governing body, the Common Council, with the board's recommendations on master plan consistency review, that is when there's a public hearing, and that is when all members of the public have an opportunity to weigh in on the actual ordinance itself. So again, the narrow frame of reference and authority for the planning board is simply whether the ordinance is, and we do the double negative for a reason, not inconsistent with the master plan. The reason it's not inconsistent as the standard is because, and I'll read from the statute 62A, it requires every zoning ordinance to be either substantially consistent with the land use plan element and the housing plan element of the master plan, or designed to effectuate such plan element. And the Supreme Court in the seminal Manalapan Realty case weighed in on what substantial consistency with the master plan is, and the court said that clearly some inconsistency is permitted, provided that the ordinance does not substantially or materially undermine or distort the basic provisions and objectives of the master plan. So I was saying about close enough. Close is more than close enough. Substantial consistency is simply not substantially or materially undermining or distorting the basic provisions and objectives of the master plan. So that is your standard of review. That is your charge as a planning board. We provide a one-page, I am capable of drafting a one-page resolution. Here's proof. We provide a one-page resolution that simply says, based upon the report of Mr. Burgess, who we'll hear from momentarily, our planner, the board hereby finds and determines the ordinance is not inconsistent with the master plan, and that's the report back to the governing body, if that is what you find. If you find otherwise, we can remove the word "not" easily enough from that phrase. So it's up to you to make that determination after hearing from Mr. Burgess. The reason we provide the one-page resolution is so that you can move right to adopting the resolution, which is your report back to the governing body, so you don't have to do it in 2 steps.
Thank you, Mr. Warner.
Okay, I hope that clarifies it at least a little more than it might have been before.
And just to reiterate, so our deliberations today are a discussion among the panel. It is not a public meeting for that purpose, though there will not be public comment invited today, but there is a public meeting on June 11th when the public will have an opportunity to, at council.
That's absolutely correct, Mr. Chairman. My understanding is the ordinance was introduced May 21. It's scheduled for a second reading and public hearing before the Common Council on June 11, well more than 10 days, which is a statutory requirement. And again, we are within that interim period to do our job, which is to weigh in on the master plan consistency review.
Councilwoman Hamlet? Yes,
Well, and if I may, correct me if I'm wrong, Mr. Warner, but there will be a point at which the public can come back to the planning or zoning boards upon whether or not the council approves of the overlay zone. That is the public-facing process in which they can talk about all of the things that they want to talk about: development, parking, noise, all of those things, correct?
Certainly in the process, not only will members of the public have an opportunity during the public hearing, which is currently scheduled for June 11 before the Common Council, to weigh in on the ordinance itself, the merits of it, not tonight, but then, but also if that ordinance is indeed adopted, then ultimately nothing would happen development-wise until there was an application for presumably site plan and maybe some variance relief, presumably before this board as opposed to the zoning board. So there would be that another opportunity after June 11 to weigh in on an actual development application, assuming the matters proceed to that.
Thank you for that clarification. So this is just an administrative function only, and there will be an opportunity from planning or zoning again, but it will only be after public bid would be for this property.
Correct. This is, yes, this is
Okay,
just
thank
the
you.
master plan consistency review.
All right, thank you. Thank you, Ms. Hamlet. Mr. Burgess?
Okay, thank you. I was glad to hear the councilwoman use the word administrative function. It is such an administrative function in contrast to a public hearing function that I don't even get sworn in because I'm not technically testifying.
Correct.
The statute's interesting. You have 35 days from the time the council refers the ordinance to you to take an action. And you could decide that it's consistent or inconsistent or partially consistent. And you make that recommendation or comment back to the governing body, then the governing body can do as they wish anyway. They could accept your recommendation in whole or in part, or reject it in whole or in part. So it's a pretty fluid process that the state legislature had established. But with respect to this ordinance, I think everybody's aware that it consists of 4 lots, and the 4 lots encompass a total of 1.6 acres in size. The property fronts on both Broad Street and Cedar Lane, as well as Morris Avenue, and 3 of the 4 parcels are already owned by the city. Lot number 1 is the Chestnut Public Parking Lot, that's at 406 Broad Street. Lot number 3 is the Firehouse property, and as I think everybody knows, the Firehouse is going to be relocating to a new site sometime this summer, and that's at 384 to 392 Broad. And lot number 4 is developed with an office building at 7 Cedar Street. Lot number 2 is the one lot that's privately owned. That's that 20-foot wide sliver. There's a driveway on that property at present. In terms of the ordinance itself, its purpose is designed to accomplish a few very specific things. It specifically talks about encouraging inclusionary multifamily housing development. It talks about encouraging a certain amount of public parking. It also speaks to the issue of encouraging some usable open space. And in addition, it talks about providing some accessibility to St. Teresa Memorial Hall. All of that has to be done within the context of a comprehensive integrated design, and that is why one of the ordinance provisions requires a minimum of at least 1.5 acres to ensure that the property will be developed as an integrated whole rather than in piecemeal development. The permitted uses are 4 specific categories of uses. They include multifamily residential development. It includes mixed-use development with at-grade retail establishments. It also includes office uses exclusive of medical and dental offices. And it also includes townhouse development, including stacked townhouse design. It has the conventional accessory use categories. It's basically saying anything that's customarily incidental to a permitted use would be allowed. It does expressly prohibit a certain number of specific accessory uses, including drive-through facilities, including detached garages and sheds, and also standalone parking structures. There's a whole host of area and bulk requirements associated with this zone. I'm not going to list them all, but some of the more significant ones are that minimum tract area of 1.5 acres. There's an FAR standard of 115%, and that is specifically designed to encourage the use of the overlay zoning rather than the underlying business zone. It permits a maximum density of 30 units to the acre. It does, however, if you do something less than that, it still does in fact require a minimum of 7 affordable units to be constructed on the site. There's an interesting limitation that restricts the maximum length of a building to 180 feet on the property, and I think that was truly a function of a lot of the comments in a recent hearing on a portion of this property. Building heights are limited to 3 stories and 36 feet. There is a provision whereby it can be increased to a 4-story, 46-foot tall building, provided that that upper floor is set back farther into the building design. And there's a whole host of building design criteria, a lot of which is already spelled out in the ordinance, and anyone who develops the site will have to adhere to those standards. If the council were to adopt this ordinance, there would then be a request for proposals from prospective developers, and that process would have to play out in front of the governing body. And as Steve had mentioned, once that takes place, it would be at that point where it would eventually come back to this planning board for site plan review. Now, one of the other things that this ordinance does, it does mandate that prior to the formal submission of this to this body, there's a series of technical review meetings to iron out some of the technical details of an application and ensure compliance to code to the maximum extent possible. Now, as Steve had indicated, the bottom line issue really is all about, is this consistent or not? And everybody calls this a consistency review. In point of fact, it's actually an inconsistency review. And as you know from our memo, we have concluded that the rezoning is not inconsistent with the master plan. We looked at both the 2000 master plan and the 2015 downtown plan and the 2016 master plan revision / reexamination report, as well as the most recent housing element and fair share plan. And all of those documents are pretty consistent with each other in terms of its goals and objectives. They talk about implementing parking strategies that prioritize parking for visitors and residents and workers in the area. It talks about promoting mixed-use development. It talks about encouraging inclusionary development. And it talks about encouraging a compatible intensity of use that is not inconsistent with the established development pattern in the municipality. So recognizing that in each and every one of those instances, this ordinance is consistent with those provisions, it's safe for us to have concluded that this ordinance is in fact consistent with the master plan, and therefore you can determine that it's not inconsistent with the master plan. And with that, I'd be happy to answer any questions from the board. Yes.
Well, Joe, I'm not going to call you out. You did a great job, so thank you. I will make one correction for public record, if I may. I think, correct me if I'm wrong, I think you might have made an error in saying that the maximum is 30 units, but in fact, that's the minimum. I think it was just, I just want to clarify for the record, we're on the same page. The minimum is 30 units. The maximum would be 48 per tract.
Right.
Per-
I'm sorry, what I heard was that 30 per acre.
30 per acre.
Okay, I just want to make sure.
Which still gets you to 48 because it's 1.6 acres.
Okay, got it. I just want to make sure we're on the same page. So
Thank you,
if,
John.
sorry, I just want to make sure I'm like, okay, I'm listening. So in the instance of if a developer picked 30 units on one tract, or let's just say 30 units, the minimum affordable housing in that tract would be 7, correct?
Correct.
Which is, what is that, 23%?
Something less than
But I just want to
30.
make sure, okay, I thought I heard you say the maximum was 30, and that's the only thing. I just want to correct and make sure we're on the same
No, it's
page.
30 to the acre, and
30
this is a
to- okay.
1.6 acre.
Got it, okay,
site.
perfect, thank you. That was the only one.
From a practical perspective, Joe, I mean, how can the planning board be helpful, I assume, to the conversation that the public should be having and that the mayor and common council should be having? It's easy to kind of check the box on inconsistency or consistency, but I assume we're kind of spurring a conversation that should arise at the next hearing.
Yes, it's the governing body's responsibility to have that public hearing,
Right.
and that's where the public comment will take place, and both myself as well as Tom from my office will be at that hearing to assist in that.
Is it best to focus on the goals, for example, from the 2016 reexamination and make sure that in broad strokes, if this conforms with the intent of that particular document or the others that are mentioned here?
Yes.
Okay.
If I may add, Mr. Chairman, with your permission, I like to refer to the planning board as the gatekeepers of the master plan. That is, we alone, separate and apart from the governing body, adopt the master plan and are, in essence, the gatekeepers. So that is why the governing body comes to us for the review of consistency or inconsistency. I thought only lawyers use double negatives. Now I know planners use double negatives as well, which gives us company. So that is the narrow scope, and that's the way we can, in my opinion, and the MLUL's opinion, best facilitate the process for the next step, the governing body.
Can we pick up on one thing you had mentioned, is that the review is meant to assess the consistency or substantial inconsistency, however you want to look at it, between the master plan, but also the housing plan elements. You called that out specifically in one of your comments there.
Yeah, well, every municipality's master plan will have, there's mandatory plans and a housing plan and a land use element. Those are mandatory elements. So those are somewhat of a focus, if you will, for consistency purposes. But really, it is and please correct me if I'm wrong, Mr. Burgess, our planner, it is the master plan in whole. All elements are relevant to the inquiry.
Recognize a master plan can consist of many different elements. The statute identifies about 15 different elements. The only obligatory ones are the land use plan and the housing element and fair share plan.
And the statement of objectives.
And the statement of objectives, but that's always part of the master plan, or land use plan. I might have neglected to mention the housing element and fair share plan, but that was designed to implement the settlement agreement that the municipality has with Fair Share Housing Center. And in that settlement agreement, it specifically does talk about encouraging inclusionary development, and that's why it really all ties together nicely.
I think you'd mentioned in your memo here, the site is not currently listed as a plan mechanism in the city's 2018 housing element and fair share plan. So if we're going to put a special emphasis, shine the light on the housing element for just a moment, if anything, this codifies, makes consistent, perhaps even arguably to Delia's point, improves the likelihood of development, and by codifying that affordable housing component will encourage the development of affordable housing.
Correct.
This lot.
And what's interesting is that in the settlement agreement and then in the implementing ordinances for the housing element and fair share plan, there is a requirement for a mandatory set-aside ordinance for any multifamily development. So that really ties the bell around it all.
All right, I'll be quiet for a minute. Go ahead.
Through you, Mr. Chairman. Steve, I think it's such an important point, and I spend more time in this document, the Housing Element and Fair Share Plan from 2018, and if you really read it, you've been doing so much work on this for so many years, Joe, and it literally lays out all of the overlay zones, what they were designed to do, So this is not something that the Common Council just came up with, and I live and breathe it, but I want to make the other members of the planning board, I know Matt Delory lives and breathes it too, but, you know, you want everybody to feel comfortable and know that you should feel comfortable reading this document, and that we've been doing this for years. These overlay zones, the 8 or 7, 8, I think we have 8. They have there were very specific reasons in our settlement agreement that we created those overlay zones. They were required for a reason, there were mandatory set-asides for a reason, and you should feel very comfortable, in my opinion, in reading that document and knowing that this is consistent in that same path.
Yes, it does. Thank you.
Do you have any other comments or questions from the board? Well, thank you very much, Mr. Burgess.
Okay, my pleasure.
At this time, I think, well, we have a one-page resolution from Mr. Warner, which allows us to refer this matter back to the council and with a decision that it is not inconsistent with the master plan.
If that is your vote.
And so at this time, I take a motion to approve the resolution.
Sorry, Mr. Zucker, is there meant to be more substantial deliberation, or we kind of kick the tires on it and we just proceed?
You know what, I'm happy to deliberate more. I just thought we got our
Yeah, I
questions.
just want to be useful to council and kind of the process, but is there anything else, Mr. Burgess, that Tom's going to be up there at the podium at the next meeting wishing we had said or discussed?
No, actually, I think we covered it all.
Okay.
Pretty comprehensive.
Mr. Burgess, just one question. The document doesn't specifically, for instance, reference the design guidelines that we've worked hard to include, but they are by implication included, I take it, in any proposed plan for that site.
That is correct. And in the ordinance, it actually does identify the fact that you have to comply with those design principles.
Thank you very much.
I have one more comment. I just want to be clear on, can you opine on the open space, Mr. Burgess, as far as like what that will bring to the community? It's not necessarily, it's obviously, you can.
What the ordinance, this is one of the many things I did skip because I thought, yeah, that other application. The ordinance does specifically say that at a minimum, there has to be 9,000 square feet of contiguous open space with a 100-foot linear dimension along Broad Street. And it's designed to ensure that we get a substantial amount of common open space that will really add a visual feature and focal point to however the development takes place on the site. So it's mandatory, and I think there's really no getting around the requirement the way it's spelled out in the ordinance.
And I think through you, Mr. Chair, this is something that is not prescriptive, right? We're not designing what's going to go on this site, and I think it's important for the public to understand that. This is something that is going to be a public process, a public bidding process, and that's the most important thing, that we're not stating what's going to be on that site. It's a flexible space, and we've been talking about getting these properties up for sale for a long time while also achieving our affordable housing goals. So that's why I'm happy to support this ordinance.
Maybe just to double tap on what Delia was saying too, is when I looked at the 2016 reexamination, the first goal, which is guiding development to maintain and enhance the character of Summit, the overlay zone as proposed is not overly constrictive, is not out of conformance with our DRO, with even our experience, frankly, in other planning or zoning applications that we've seen in recent years, and certainly reflective of public comment that we've heard in recent years, focused intensely on that site. So if anything, this will, through the able guidance of Mayor and Common Council and the city administration, hopefully open a process where we'll see a diversity of viewpoints and interests and creative ideas that'll land this really at the best possible end result. For that, I too could support the resolution as Steve has drafted. I won't even try to tiptoe through the double negatives.
Any other comments or thoughts from the board?
No, I'll just add on that I think this is a good transition zone that allows for flexibility. I did watch a little bit of the council meeting, saw the presentation, which went into more detail in terms of density, minimum, maximum, the flexibility to allow for business while also promoting mixed residential use. So with that and some of the concerns I've heard over the past and looking at the master plan, certainly will be in support of this, as I do not think it's not, whatever, the double negative, the right way. So I'll be supporting.
I would just like to add that, this board has been looking at this project and this piece of land for years. We have found similar development, larger development, somewhat consistent or not inconsistent. And this program actually really, I think, gives the public a chance to get the best value out of this property and move this project forward. I don't see how, in my view, it is certainly not inconsistent, considering that we have already been looking at this for years, and this is really what we're looking for. So,
And that-
Okay. Can I make a motion to, what do you want me to say, Steve?
You could just adopt the
Can we
resolution,
adopt the resolution,
providing that. the
provided
board-
that the ordinance is not inconsistent with the city's master plan?
You got it.
How about that?
do I
I'll
have
make that motion.
Thank you, Mr. Spur. Do I have a second?
Second.
Mr. Philbin, thank you.
Chairman Zucker,
Yes.
Mr. Spur,
Yes.
Mr. Felmet,
Yes.
Councilmember Hamlet,
Yes.
Mr. Delory,
Yes.
Ms. McGee,
Yes.
Ms. Bowen.
Yes.
The motion carries.